Let's discuss consent of parties now. Friends, consent in any contract is very important. There can be no contract without any consent. So under section 13, consent means two or more persons agreeing upon the same thing in the same sense. Take an example. Mr. A offers to sell his scooter for 10,000 rupees to Mr. B and Mr. B agrees to buy. So this contract has consent of both the parties and both the parties agree on the same thing in the same sense. Now take another example. Mr. A offers to sell 1000 liters of oil to Mr. B for 1 lakh rupees and Mr. B agrees. Later, it was found that Mr. A intended to sell hair oil while Mr. B intended to buy cooking oil. So, in this case, there is no consent because the parties did not agree on the same thing in the same sense. One thought it's hair oil and the other thought it's cooking oil. So for a valid consent, it is important that parties must agree upon the same thing in the same sense. Now, do you think in order to form a valid contract, there just need to be a consent irrespective of how the consent is obtained? What if I put a gun on your head and ask you to sign the contract? What if I blackmail you and exert pressure on you to enter into a contract? What if I obtain your consent by cheating? What if I obtain your consent by giving you some misleading information? What if the consent is obtained by mistake? So friends, having consent in an agreement is not enough. There has to be what we call it as free consent. Now what is free consent? According to section 14, free consent means when a consent is not obtained by coercion, undue influence, fraud, misrepresentation, and mistake. These are the 5 evils or 5 grounds on which a contract can become invalid. If a contract is entered into because of any of these 5 reasons, then contract cannot be said to have entered with the free consent. Just remember these 5 grounds and we will discuss these one by one in the coming slides. So friends, the first ground which makes a contract invalid due to lack of free consent is coercion. Coercion is defined under section 15 of the Act. Let me read the definition for you. According to this section, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever with the intention of causing any person to enter into that agreement. Friends, the definition of coercion has 2 parts. The first part is committing or threatening to commit a crime under IPC. So it includes both committing as well as threatening to commit. For example, Mr. A puts a gun on Mr. B's head and asks him to sign the contract. Mr. B signs the contract. Now, this contract is entered into by coercion because killing or threatening to kill is an offense in IPC. Similarly, if Mr. A kidnaps Mr. B's son and asks him to sign the contract as a condition to his release, and Mr. B signs the contract, this is again coercion as kidnapping is an offense under Indian Penal Code. So, important point to note here is that both committing as well as threatening to commit an offense will amount to coercion. Now, the second part of the definition talks about unlawful detention of property or threatening to detain the property. Again, both things will amount to coercion, detaining or threatening to detain. Now, property here means movable property as well as immovable property, right? For example, Mr. A refuses to return Mr. B's car unless Mr. B buys bike from Mr. A. Here, refusing to return the car is unlawful detention of movable property of Mr. B. Okay, so remember there are 2 points in the definition of coercion. The first point talks about committing or threatening to commit an offense under IPC, and the second point says unlawful detention or threatening to detain the property. And both these acts are done with an intention to cause any person to enter into an agreement. Let's discuss a few more points about coercion. Friends, it is important to know that it does not matter if Indian Penal Code is applicable at the place where coercion is applied. If a suit is filed in India, Section 15 will apply. For example, Mr. John threatens to kill Mr. Raghu in Australia if Mr. Raghu does not enter into an agreement with him for sale of his property in India. Mr. Raghu signs the contract. But upon his return to India, he files a legal suit in Calcutta for repudiating the contract on the grounds of coercion. Mr. John argues that the provision of Section 15 of Indian Contract Act does not apply as the Indian Penal Code is not applicable in Australia. The court held if the suit is filed in India, the provision of Section 15 will apply and it does not really matter where the act of coercion was committed. Clear? Now, another important point. The act of coercion need not necessarily be directed towards the person who was a party to the contract. The only thing that court will look into is that if the act of coercion actually induced a person to enter into a contract. For example, Mr. A threatens to shoot Mr. C, who is a friend of Mr. B, if Mr. B does not enter into a contract with Mr. A. Okay, here the act of coercion is not directed towards Mr. B, but Mr. B's friend Mr. C. So here the provision of Section 15 will still apply and Mr. B can still approach the court to cancel the contract on the ground of coercion as Mr. B entered into a contract to save his friend Mr. C and not by his own free will. Clear? Now friends, can you tell me if the following acts will amount to coercion according to you? Why or why not? First is threatening someone to file a legal suit or court case against you. Pause the video, take some time and think over it. Okay? Alright. So the answer for this question is no. Threatening to file a legal suit or a court case will not amount to coercion because filing a legal case is not an offense under Indian Penal Code. In fact, it is your right. However, if you're threatening to file a false legal case against someone in order to force that person to enter into a contract, then it will amount to coercion. Clear? Okay, next one. Threatening to commit suicide. What do you think? Take your time, think about it. Threatening to commit suicide. Okay, so answer for this one is again no. Threatening to commit suicide is not an act of coercion because neither suicide nor threatening to commit suicide is an offense. Only attempt to commit suicide is an offense under IPC. Alright, so this will not be covered under coercion. Now, what is the effect on a contract if it is proved that contract is induced by coercion? Well, if it is proved that a contract is caused by coercion, the aggrieved party to the contract have an option to repudiate or cancel the contract. And if the aggrieved party chooses to repudiate the contract, then it will have to restore and return any benefit it received under the contract because aggrieved party cannot be allowed to take benefit from a contract which it chooses to cancel because it was against its free consent. Okay.
Now, the second element, the presence of which constitutes lack of consent, is undue influence. Friends, undue influence means applying inappropriate or excessive influence on someone to induce him or her to enter into the contract. Friends, sometimes there are situations where one party is in a dominant position than the other. For example, your boss in the office is always um, in the dominant position than you, right? He can apply undue influence on you and make you do certain things which may not be justified. And you will still do those things because you fear that if you don't do what your boss says, you'll be fired from the job. So if this was just an example, let's understand undue influence better. The term undue influence is defined under section 16 of the Act. Keep this section in mind. Definition according to this section is a contract is said to be induced by undue influence when the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other, and he uses the position to obtain an unfair advantage over the other. Friends, position to dominate the will of that other means that the party has such relationship that he or she can make the other party work against their will. Normally, a person seeking to set aside a contract on the grounds of undue influence will have to prove two things. First, that the other party was in a dominant position. Second, that the other party used his dominant position to obtain an unfair advantage over him. Now, there are certain relationships when a party is presumed to be in a position to dominate the will of the other party. This is clarified under section 16 subsection 2. Under subsection 2, there are three situations where the dominant position is presumed by the courts. First, when party hold a real or apparent authority over the other party. For example, boss and employee, master and servant, police officer and accused. Your boss can dominate your will, right? A police officer can also dominate the will of the accused because he's placed in a position of authority to dominate the will of the accused, right? Second situation, where one party stands in fiduciary relationship with the other party. Fiduciary relations are the relations where there is a mutual trust and confidence. For example, a relation of father and son. Father can dominate the will of son, and the same way son can also dominate the will of father. Similarly, relation between advocate and his client, doctor and patient, and other like relationships are also considered as fiduciary relationships. Third situation, where someone makes a contract with a person whose mental capacity is permanently or temporarily affected by the reason of age, illness, or mental bodily stress. For example, if you make a contract with an old and illiterate person who cannot understand the terms and conditions of the contract, such contract will deemed to be induced by undue influence. Similarly, if you make a contract with a person suffering from illness or who is not in his senses while making the contract, then such contract is also deemed to be induced by undue influence. So there are three situations where the parties will be considered to be in a position to dominate the will of that other, right? First is when the party hold real or apparent authority over the other party. Second, when one party stands in a fiduciary relationship with the other. And third, when someone makes a contract with a person whose mental capacity is temporarily or permanently affected by the reason of age, illness, mental or bodily distress. Okay, but friends, remember, it is not just enough to show that a party was in a position to dominate the will of the other party to prove that the contract was induced by undue influence. The second element of the definition of section 16 subsection 1, which says and he uses his position to dominate the will of that other. So it must be proved that not just the party is in dominant position, but the other party also uses its dominant position to obtain unfair advantage over the other. For example, if a son convinces his old mother to sign a contract which divides property, giving him 70% and his brother 30% share in the property, then this will qualify as a contract induced by undue influence. As the son here is in a dominant position because the mother is old and illiterate, she cannot understand the terms and conditions. But not just because of this reason, he also used this position to obtain an unfair advantage, that is unfair share in the property, right? If he just makes a contract and there is no unfair deal in that contract, then the contract is perfectly valid even if the mother is illiterate and old. But what makes a contract invalid on the grounds of undue influence is that the son was in dominant position and he used his dominant position to influence her mother to enter into an unfair deal. Okay, hope this is clear. Presumption of undue influence. Friends, let's understand what is meant by presumption under the law. Presumption means assuming anything even before it is proved. So generally under the business law, the general rule is that the one who claims any relief basis on any wrongdoing have to prove in the court. The burden of proof is on the person who claims. That's the general rule. However, under certain circumstances, court presumes the wrongdoing and puts the burden of proof on the party who's accused of doing the wrong. Now, this person who's accused of doing the wrong have to prove to the court that he did not do any wrong. So, does any presumption exist for undue influence cases? If the undue influence case falls under any of the three situations I explained before, which are mentioned under section 16 subsection 2, then the court will presume undue influence in such situations, and the burden of proof will lie on the other party to prove that he did not induce the contract through undue influence. If he cannot prove that, court will declare contract to have been induced by undue influence. Right? Also note that undue influence is not presumed to exist in case of husband and wife, mother and daughter, grandson and grandfather, landlord and tenant, debtor and creditor. In such cases, presence of undue influence in a contract has to be proved by the person who claims it to be so. So what is the effect of undue influence on a contract? Section 19A. Under Section 19A, if it can be proved to the satisfaction of the court that the contract was induced by undue influence, the agreement is voidable at the option of the party whose consent was so caused, or if the party who was entitled to avoid it has received any benefit thereunder upon such terms and conditions as the court may seem just. Friends, as per Section 19, even in coercion, fraud, and misrepresentation, any benefit received by the aggrieved party has to be restored under Section 64 of the Act. However, Section 19A, which applies in case of undue influence, is slightly different. As per Section 19A, it is up to the discretion of the court how much benefit the aggrieved party is directed to refund. The court may order full refund, partial refund, or even no refund of any benefit received by the aggrieved party. Right? Friends, I'll briefly touch upon provisions of undue influence with respect to Pardanashin women. Pardanashin woman is a woman who observe rigid rules of seclusion. They stay in parda or veil. Friends, imagine you enter into a contract with an old and illiterate lady. After the contract, the old lady goes to the court and says that she is old and illiterate and she does not know what the contract is all about, and she was made to enter into the contract through undue influence, and that she wants to cancel the contract. What will court do in such a case? Court will most likely see the condition of the lady and may rather ask you to prove that the contract was not induced by undue influence, because the court will presume that there are high chances that an old and illiterate lady can be fooled by someone to enter into a contract. So the burden of proof shifts on to you. Just like I explained about other presumptions that court take in cases of undue influence, similarly, undue influence is presumed in case of a Pardanashin woman. So if you make a contract with a Pardanashin woman, be very careful. If a Pardanashin woman later claims that the contract she entered with you was induced by undue influence, then the court will accept what she says, and court will ask you to prove that you did not apply undue influence on her to enter into the contract. And to prove that you did not apply undue influence, you will have to prove to the court that the terms of the contract were fully explained to her. She understood their implications and was free to have an independent advice in that matter. She freely consented to the contract. You have to prove this to the court, these 3 points. So you can see how much protection is granted to Pardanashin women, and the same is extended to other illiterate and ignorant ladies to protect their interest. Okay. Now quickly see the difference between coercion and undue influence. It is likely to be asked in your law examinations. So the first point of difference: coercion is committing or threatening to commit any act forbidden by Indian Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person, whatever, with the intention of causing any person to enter into the agreement. While in undue influence, the free consent of the other party is influenced by the dominance of will of one person over another, right? So there is a difference in the definition itself. Second, coercion means applying physical violence or force, like putting a gun on the head or maybe hitting someone. But in undue influence, moral force and mental pressure is used to influence the free consent of the party. For example, son threatening to commit suicide if the father does not sell his bungalow to him. That's undue influence, right? Third, in coercion, there is no presumption by the court, and the burden of proof that the contract was entered into by coercion lies on the person whose consent was so caused. But in undue influence, there are situations where the undue influence is presumed by the courts, and the burden of proof shifts onto the other party, right? Fourth, fourth difference relates to restoration of benefit. In coercion, aggrieved party is required to restore the benefit it received under the contract under Section 64, whatever benefit it has received under the contract. While in undue influence, it is up to the discretion of the court as to how much benefit it may direct the aggrieved party to restore. So it may be possible that the aggrieved party is not directed to restore all the benefit, or it may be possible that court direct the aggrieved party to restore all the benefit. It all depends on the discretion of the court. Okay, but in coercion, you have to return whatever benefit you have received under the contract. Fifth point of difference: in coercion, the party applying coercion exposes itself to the criminal liability under Indian Penal Code, whereas under undue influence there is no such criminal liability, right? Because in undue influence you do not use any physical force or violence. It's mostly moral or mental pressure. Okay, let's discuss fraud now. Fraud basically means any act committed with an intention to deceive the other person. There are various ways through which a person can commit fraud on the other person. For example, you can defraud someone by saying a lie, or by concealing some important information, or by playing tricks on someone. Let's discuss in this lecture what are the situations which are covered under fraud. Fraud is defined by Section 17 of the Act. According to Section 17, fraud means and includes any of the following acts committed by a party to the contract or with his connivance. Connivance means allowing some wrong to happen, or by his agent. This means the fraud can be committed by the person who is party to a contract or even by his agent, with the intent to deceive or to induce another party thereto or his agent to enter into the contract. Now, what are the acts that constitute fraud? First is the representation that a fact is true when it is not true by one who does not believe it to be true. This means the false statement is intentionally made to deceive the other person. If you compare this statement with the first point of misrepresentation, then you will note that in misrepresentation also there is a false statement, but there the person actually believes it to be true. So there was no bad intention there. Here in fraud, the person knows that the fact he's trying to represent as true is actually not true. So there is a bad intention to cheat the other person. Take an example. Mr. A offers to sell his horse to Mr. B and represents to Mr. B that the horse can run at the speed of 100 km per hour, basis on which Mr. B buys the horse. But in reality, Mr. A knows that the horse can't even run 50 kilometers per hour. In such a case, Mr. B can repudiate the contract on the grounds of fraud. Okay. Second act which constitutes fraud is the active concealment of a fact by a person who has knowledge and belief of the fact. So here, the person is not making a false representation. Rather, he is concealing a material fact of which he has knowledge and belief. Again, this is intention to deceive. The person knows some material facts but deliberately conceals so as to induce the other person to enter into a contract. Material fact means a fact which can impact the decision of the other party whether to enter into a contract or not. A person is bound to disclose material facts to the other party. However, a person is not bound to disclose any fact which is not material. If a person does not disclose a non-material fact, then it cannot be called as fraud. It is for the other party to inspect and do proper due diligence to find out any non-material facts. For example, Mr. A sold his car to Mr. B, but deliberately does not disclose the fact that car's engine overheats during long drives. Such a contract will said to be obtained by fraud because overheating of engine is a material fact. Nobody would want to buy a car um, which has a defect in the engine, right? So it's a material defect, and if you conceal this material defect, it would be called as fraud. Third act is that a promise is made to the other person without any intention of performing it. For example, Mr. X purchases some goods from Mr. Y on credit with the intention of not paying any amount due to Mr. Y as he is under insolvent circumstances. Such a contract can be repudiated on the grounds of fraud by Mr. X. Clear? Next one. Any act or unfair method used to trick or cheat someone will be fraud. This subsection will cover all the acts of deceiving not covered elsewhere. And the last one is any such act or omission as the law specially declares to be fraudulent. There are certain acts which make it compulsory for a person to disclose the facts. For example, Section 55 of the Transfer of Property Act requires the seller or immovable property to disclose to the buyer all material defects in the property. If the seller omits to do that, then it may amount to fraud. Okay.
Now, a very interesting question. Can silence amount to fraud? Explanation to section 17 deals with this question. As a general rule, mere silence as to facts cannot be regarded as fraud. For example, you go to a car showroom to inquire about a new car you intend to purchase. The sales guy in the showroom tells you great things about the car, but stays silent on the mileage part because he knows that car's mileage is quite low compared to the other cars in the market. Now, if you buy the car, then later you cannot sue the company or salesman because the salesman stayed silent on the mileage part. The law here says that it is buyer's responsibility to do the required research before buying. However, there are cases where there is an obligation on the person keeping silence to speak. Otherwise, such silence will amount to fraud. These are the cases where there is no other way a party can get complete information unless the other party makes a full disclosure. There are five such cases, or we can say five types of contract where a person keeping silence is duty bound to disclose all the facts to the other party. These are the contracts or relationships of utmost good faith. The first one is a contract where parties are in fiduciary relationships. Fiduciary relationships are the relations of mutual trust and confidence. Some of the fiduciary relationships are father and son, advocate and client, trustee and beneficiary. So, for example, father sells a horse to his son. Father knows that horse is of unsound mind. Now, since the relation between the parties are fiduciary relation, father is duty bound to disclose to his son that horse is of unsound mind. He cannot stay silent on this fact, otherwise this will amount to fraud. Here, the second one is contracts of insurance. In contracts of insurance, such as life insurance, health insurance, or fire insurance, the insurer agrees to compensate the insured for the loss provided all the material facts are disclosed by insured to the insurer. Here, the insured person is duty bound to disclose all material facts to the insurer and cannot choose to be silent. For example, a person takes a health insurance, but at the time of buying the health insurance, he remains silent on the fact that he already suffers from a heart disease. Here, the contract of insurance can be repudiated by the insurer on the grounds of fraud. Third one is contract of marriage engagement. Here also both the parties, that is the bride and the groom, must disclose every material fact to each other, otherwise the aggrieved party will be justified in breaking off the engagement. Then comes the contracts of family settlement. In case of family settlement also, full disclosure should be made between the parties. For example, parties must make a clear disclosure of the market value of the property and the actual sale price of the property. Last one is share allotment contracts. Friends, when a company needs money, it issues shares to the public. Before issuing shares, the company rolls out a prospectus which describes the current and future prospects of the company. Based on this information, public decides whether to invest their money into shares or not. So, if any material disclosure is not made in the prospectus by the company, it will amount to fraud. So, a company cannot remain silent on material information which it should be disclosing in the prospectus. So, these were the five types of contracts where silence will amount to fraud and a party is duty bound to disclose all material facts to the other party. Now, one last important point where the silence is equivalent to speech in such cases, remaining silent will amount to fraud. For example, A says to B that if you do not deny, I will assume that horse you are selling is of sound mind. Now, if B stays silent, that will mean that horse is of sound mind. Later, if the horse is found to be of unsound mind, B will be guilty of fraud and can be sued by A. I hope that is clear. Now, what is the effect of fraud on a contract? The aggrieved party has three options here. First, of course, he can rescind the contract because the contract is voidable at his option. Second, he can ask for restitution and insist that he be placed in the same position had the representation made to him was true. Third, he can claim compensation for any loss he may have suffered because of such fraud. So these are the three remedies which an aggrieved person can claim in case of a fraud. Now let's quickly look at some important points relating to fraud. First, fraudulent representation must be a major factor leading the other party to enter into the contract. That means the other party would not have entered into the contract if such fraudulent representation was not made. Second, the other party must have been actually deceived by the fraudulent representation. If the other party was not deceived, it cannot amount to fraud. Third, to claim damages, the other party must have suffered some damage or injury, otherwise, no action will lie. Fourth, this one is important. In case of fraudulent silence, the contract is not voidable if the other party had means to find out the truth with ordinary diligence. Like in the car example that I gave you, the party could have found out about the mileage of the car simply by researching over the internet. So in this case, you cannot make the sales guy or the car company liable for fraud, right? Now, for any other types of fraud, even if the other party had means to find out the truth with ordinary diligence, it will still amount to fraud. And the other party not using its diligence will not be a defense. Clear?
Now, another element is misrepresentation. Misrepresentation is defined under Section 18 of the Act. This is a big definition, so don't get intimidated. I will simplify it for you. There are three parts of this definition. The first part says misrepresentation means and includes a positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believe it to be true. In simple words, this means a statement of fact made by a person which he believes it to be true, but is actually not true. Here, the false statement is made innocently by the person without any intention to deceive the other party. We call this in Hindi as galat fahmi. Okay, take an example. Mr. A intends to sell his car to Mr. B and tells him that his car gives a mileage of 20 kilometers per liter, though in reality, the car gives a mileage of 14 kilometers per liter only. Here, Mr. A actually believes that his car gives a mileage of 20 kilometers per liter and do not intend to deceive or cheat Mr. B. Such a case would fall under the category of misrepresentation. Okay. Second part of the definition. Any breach of duty which, without an intent to deceive, gains an advantage to the person committing it or anyone claiming under him by misleading another to his prejudice of any claiming under him. Friends, whenever we get into any commercial transaction, there is an implied duty to make full disclosure of the facts. All right. Now, take an example. Mr. A intends to sell his car to Mr. B. Mr. A explains great things about his car to Mr. B, but unintentionally missed to inform Mr. B that his car sometimes take time to start at random intervals. Mr. A never intended to deceive or cheat on Mr. B, but the fact of car not starting at random intervals slipped from his mind. He just forgot it. Such a case would also fall under the category of misrepresentation, as it was his duty to disclose that the car may take some time to start, which he missed informing Mr. B. As a result of this, Mr. A gained an advantage by getting more price of the car, right? Had Mr. B known that the car takes time, he might have reduced the selling price of the car, purchase price of the car, right? So it must be noted that here the defect should not be something that can be found on a reasonable examination. Here the starting issue happened randomly, so Mr. B may not be able to find this issue on a reasonable examination. If there is any issue which can be found on reasonable examination, then that cannot be called as misrepresentation, because the other party is supposed to check himself for any such defects, right? That's not a misrepresentation. But if something which you cannot find on a reasonable examination, then that would fall under the category of misrepresentation. The difference between first and second part of the definition is that in the first part, a person says something which is not true, and in the second part, a person does not say something which is true. So you getting the point? The first part, a person says something which is not true. He actually says something which is not true. In the second part, the person does not say something which is true and which he is supposed to say. He missed saying that, right? Both fall under the category of misrepresentation. Now the third part of the definition. Causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. Now, take an example. Mr. A has two bungalows, one located in Mumbai and another one located in Delhi. Mr. A offers to sell his bungalow to Mr. B without telling him the location of the bungalow. Mr. B is aware of just one bungalow of Mr. B which is located in Mumbai. So he thought Mr. A must be offering to sell his Mumbai bungalow. But in fact, Mr. A intended to sell bungalow in Delhi. Here Mr. A not explaining the location of the bungalow has caused Mr. B to make a mistake after the sale of the bungalow. Therefore, this contract can be set aside on the grounds of misrepresentation. I hope misrepresentation is clear to you all.
Now, the essential elements of misrepresentation. First, representation should be made innocently with an honest belief and without any intention of deceiving the other person. Friends, this is one of the striking features of misrepresentation, that there is no intention to deceive by the party. If there is an intention to deceive, it will amount to fraud rather than misrepresentation. Second, misrepresentation must relate to facts material to the contract. Material fact means a fact which can influence the decision of a party to enter into a contract or not to enter into a contract. Third, representation must be or must have become untrue, because if the representation is true, then there is no question of misrepresentation, right? Then representation must have been instrumental in inducing the other party to enter into the contract. This means the false representation made by a party should be the main factor for the another party to enter into the contract. Clear? Now, what is the effect of misrepresentation on the contract? Friends, a contract induced by misrepresentation is voidable at the option of aggrieved party. Actually, the aggrieved party has two options. First, to simply rescind the contract, that means to cancel the contract, or second, accept the contract but insist that he should be put in the same position had the representation made was true. For example, A sells a TV set to B, innocently representing that the TV is made in USA. However, in reality, the TV was found to be made in China. Here, A is guilty of misrepresentation. Now, B has an option to rescind the contract, or he can ask for replacement of the TV set with the one made in the USA, or he can accept the TV made in China but can ask for the difference in price between the two TV sets. Clear? Also note that misrepresentation under misrepresentation the aggrieved party is not entitled to expenses or interest. Clear? Now let's discuss difference between fraud and misrepresentation. Point number one. The fraud is committed deliberately with an intention to deceive the other party. Whereas in misrepresentation, there is no intention to deceive. The other party simply makes a wrong representation innocently. Second, fraud is a civil wrong, which means you can claim compensation in the court for any fraud played upon you. However, in misrepresentation, you can just rescind the contract and cannot claim any compensation from the court. Third, in case of misrepresentation, a party may be prevented from avoiding the contract if it can be proved that the party had reasonable means to discover the truth with ordinary diligence, but in case of fraud, except in case of fraudulent silence that we have just discussed, finding the truth on using ordinary diligence will not be a defense for preventing rescission of the contract by the other party. So these were the three differences between fraud and misrepresentation. Let's move on to the next topic. Now, one interesting point here, we have just read that in case of coercion, undue influence, misrepresentation, and fraud, the contract is voidable at the option of the aggrieved party. That means the aggrieved party has the right to cancel or rescind the contract. However, this right of rescission or right of cancelling the contract will be lost in a few cases. First, when a party, in spite of being aware of its right to rescind the contract, chooses to affirm the contract expressly or impliedly, then the right of rescission is lost. For example, A sells to B certain variety of mangoes through misrepresentation. However, B further sells those mangoes bought from A to C. This clearly indicates that B has no intention to cancel the contract and the right of rescission is lost. Second situation is where the party seeking to rescind the contract is unable to restore the benefit it may have received under the contract. For example, A sells his hotel to B for 10 lakh rupees under coercion. A invests that 10 lakh in share market and loses all the money. In such a case, A cannot rescind the contract now because he is unable to return 10 lakh rupees he received if the contract is cancelled. Clear? Third, lapse of time. This means the right of rescission is lost if the aggrieved party makes too long a delay in exercising its right to rescind the contract. The party must apply for rescission as soon as it becomes aware of any fraud, misrepresentation, coercion, or undue influence in the contract. Fourth, rights of a third party. Now, if before a contract is rescinded or cancelled, a third party acquires a right in the subject matter of the contract, then the right of rescission is lost. For example, B buys 100 kgs of apples from A through fraud. Now, before A can rescind the contract, B further sold those apples to C. Now, this contract cannot be rescinded because a third party, which is C, has lawfully acquired the right on the subject matter. That is, right on the apples sold to him by B. I hope this is clear. Let's talk about mistake in our next lecture. Mistake. This is the fifth and the last element, the presence of which makes a contract devoid of free consent. Friends, to err is human. It is very natural for humans to make mistakes. In simple words, we can define mistake as an erroneous belief about something. When it comes to mistake under a contract, we can classify mistake into two categories. First, mistake as to law. Second, mistake as to fact. Mistake of law can again be of two types. Mistake of law of country, mistake of foreign law. When I say mistake of law of country, I mean mistake as to law of India. Under Indian Contract Act, the general rule is that if you are an Indian, you are expected to know the law of your country. So you cannot avoid or rescind a contract because you made a mistake as to the law prevailing in India. So if you enter into any contract that involves complex transactions or on which several complex law may apply, of which you may not be aware, then be sure that you hire an expert such as an advocate or a chartered accountant or a company secretary for your legal advice. Because if you make a mistake of law, you will not have any right to rescind the contract and you will still be bound with the contract. So you got to be careful there. For example, A enters into a contract with B for sale of certain goods with an erroneous belief that tax rate on such transaction is 12%. Later, it was found that tax rate is 30% under the tax laws of India. Now, in this case, he cannot rescind the contract and will have to abide by his contractual obligations under the contract. He was expected to know the tax rate before entering into such transaction. Okay. Next is mistake as to foreign law. In case of a mistake as to foreign law, the contract is void. Mistake as to foreign law is treated on the same footing as a bilateral mistake, which we are going to discuss next. So now coming on to mistake of fact. Mistake of fact can be of two types. One, bilateral mistake. Second, unilateral mistake. Bilateral mistake means mistake by both the parties. There is a mistake from both the sides and both parties misunderstood each other. There is a lack of consensus ad idem, which means agreeing upon the same thing in the same sense. A contract with bilateral mistake is void ab initio, since there is no consent on the same thing in the same sense. Remember that example of oil that I gave you at the beginning of my lecture, where two parties enter into a contract for sale of oil, but the contract is void because one party wanted to sell hair oil and other party wanted to buy cooking oil. So in such a case, the contract will be void on the ground of bilateral mistake. Now there are three conditions that needs to be fulfilled for a contract to be void on the grounds of bilateral mistake. First, both parties must be under a mistake. If only one party is under a mistake, then it will be a unilateral mistake, which we'll be discussing in the coming slides. Second, mistake must relate to some fact and not to any opinion or judgment. If you make mistake because of your own wrong opinion or judgment, that will not make a contract void. For example, A pays for a motorbike thinking its value to be 50,000. However, the actual value is 30,000. Here, A cannot rescind the contract and should blame himself for the ignorance. Point number three, fact must be essential to the agreement. Now, what is meant by essential fact? Well, it could be existence of a subject matter. For example, A and B enter into a contract for sale of horse. However, neither knew at the time of entering into the contract that the horse was dead. This is a mistake as to existence of the subject matter. Then it could be a mistake as to the identity of subject matter, like hair oil and cooking oil example I just discussed before. The parties here make mistake in identifying the subject matter itself. One party thinks something else and the other party thinks something else. Similarly, there could be mistake as to the title of this subject matter. A bought a house from C and then sold it to B. However, there were some formalities left for complete transfer of title from C to A. A and B both thought that A has the complete title to make the sale. This is a mistake as to the title. Then there could be mistake F2 quantity. For example, A ordered 10 quantity of mangoes from B. A meant 10 mangoes only, but B sent 10 dozen of mangoes. Here the parties are under a mistake F2 quantity. There could be a mistake of quality. For example, A orders certain quality of mangoes from B. However, A meant Alfonso mangoes, but B sent Totapuri mangoes. Here the parties made a mistake after the quality of the subject matter. Hope this is clear. Now let's discuss about unilateral mistake after the fact. Under unilateral mistake, only one party makes a mistake after the fact. However, a contract is not voidable just because one of the party was under the mistake after the fact, unless the mistake is caused by misrepresentation or fraud. However, under certain circumstances, a contract entered into by unilateral mistake can also become voidable. Let's quickly discuss some peculiar situations where the contract is entered into by mistake by one of the parties and its impact on the contract. First one is negligence or lack of care. If one of the party makes a wrong judgment or carelessly enters into a contract without understanding its implications, then such contract will remain valid and the mistaken party should blame itself for such mistake. For example, X contracts with Y to buy what he thinks is the old wine. However, after the contract, he realized that the wine is new. Here, X cannot repudiate the contract as he should have seen himself what he is buying. Contract will not be invalid because X was careless in judging the quality of the wine. Point number two. If the unilateral mistake is caused by fraud or misrepresentation by the other party, the contract will be voidable. For example, A buys an old car from B. B secretly replaced the car engine with the engine of a much older car before selling the car. Here, A made a mistake because of the fraud committed by B. The contract will be voidable here. Third point, mistake F2 identity by the third person. A mistakenly contracted with C considering him to be B. C very well knew that A wanted to contract with B only, but still entered into the contract with A. Such agreement will be void ab initio. Fourth, mistake F to the nature and character of a written document. This means if a party signs any written document which it never intended to sign, then such document will have no value. Such signatures will have no value. The rule of law is that if a person signs something which he did not intend to sign, then such signature will have no value and the contract will be void ab initio. For example, a blind man signed a gift deed thinking it to be a sale deed. The gift deed is void ab initio since the blind man never intended to sign the gift deed. Similarly, if an illiterate woman signs a document considering it to be a power of attorney in favor of her nephew, while in actuality it was a gift deed in favor of her nephew, such gift deed will also be void ab initio. Alright, so this brings us to the end of our chapter Consent of Parties. I hope you must have found it useful. See you in the next lecture discussing a new chapter.